Hello everyone, this is Tom Fox and I'd like to welcome you to episode 212 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions, your one-stop shop for all things FCPA compliance related. Today I have with me Stephen Martin. Stephen is the head of Baker & McKenzie's Compliance Consulting Practice, and we take a deep dive into the implications of the new Compliance Counsel announced by the Department of Justice and the metrics set out by Assistant Attorney General Leslie Caldwell last week. Stephen talks about what these metrics mean and how you may utilize these in your best practices compliance program. The episode comes in at just under 22 minutes. I hope you enjoy it. Thank you very much for listening. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. I am pleased to have back with me Stephen Martin. Stephen is a partner at the law firm of Baker & McKenzie, and he heads up Baker & McKenzie's compliance consulting practice. So, Stephen, thank you, and welcome back from your whirlwind trip.
Thanks, Tom. Great to be here again.
Stephen, I've been wanting to visit with you on one particular topic because it's something that I think you're uniquely suited to visit with us about, and that's the new Department of Justice Compliance Counsel or Compliance Consultant, how that role is going to work into the types of things you do at Baker in your compliance consulting practice, how it impacts people like myself who might be outside counsel, and how, more importantly, it's going to impact the world of the compliance practitioner. So kind of with that, what are your thoughts on why the DOJ went down this road?
Well, I think, Tom, it's a great topic because I think it's great for the compliance officers and professionals because it's going to increase the visibility and importance of compliance in companies. Directly to your question about, why did DOJ do this, I think twofold. One is there was a recognition with the new head of the fraud division, when he came in, was really thinking about, do we know anything as prosecutors about compliance programs? And the answer really was no. I mean, prosecutors are very good in terms of investigation and understanding potential violations of the FCPA, but they were not really in position to be able to evaluate the effectiveness of a company's compliance program, a la the Morgan Stanley defense in terms of what you do to help protect the organization or the corporation. And then the second thing was really to bring in somebody who has real-world practical experience in running compliance programs as well as a background as a prosecutor to help guide the DOJ prosecutors when they're thinking about remedial action and measures, whether it's independent compliance reporting, monitors, other requirements that would be part of the settlement, but really making sure that those compliance enhancements, if not done by the company, that are going to be monitored by the DOJ, are really done in an effective manner going forward.
Yeah, it almost sounds like you described yourself there a little bit, but as an ex-prosecutor and as a former in-house practitioner, as someone who's run a compliance program, and now somebody who looks at it from the outside, what do you think it's going to mean? You touched on it a little bit, but could you expand on what you think it's going to mean for the in-house chief compliance officer or compliance practitioner in terms of their program?
Well, yeah, I think the biggest tension, as in-house compliance professionals know, is really this idea of return on investment of compliance, as well as always consistently trying to fight for a compliance budget or a seat at the table. And I think this new focus on compliance at DOJ and having somebody specifically assigned to be evaluating compliance programs sends a very clear message, one that's even more direct than the Morgan Stanley declination about if you have an effective compliance program, you can protect the business. This is one where now they're saying, we want and value somebody who's a compliance professional and making sure that they they know what they're doing inside of a company, because we want them to be talking to the boards of directors, to senior management, to anybody that they need to inside the company to make sure the compliance is done the right way. And the other part of that, I think, is it's going to send a clear message to boards of directors and senior management that this is critically important from a government enforcement standpoint, But B, it's also something that now you want to put adequate resources into so that you can use this in a proactive sense to both protect the business, but also, be a business that people want to work with and want to be involved with and really help it as a competitive advantage. So those are kind of key things I think compliance professionals will be signaling inside. It should help them certainly get more attention from the board of directors. And I've had some of my clients asking me, should we be telling the board about this new position and what's happening? And my answer to that is absolutely yes, because it helps you get, more established in the business at higher levels, as well as more direct contact to boards of directors who are worried about these things. And it also sends the right message to senior management that, look, compliance is there and just as important as the other components of the senior management team in being able to help the business really effectively reduce risk and maximize profitability, and then also protect it from any kind of government enforcement action that might come downstream.
I was very interested to see, Stephen, that last week Leslie Caldwell, Assistant Attorney General Leslie Caldwell, gave a speech where she talked to compliance practitioners primarily in the financial industry, but in her remarks, she talked about the metrics that the Compliance Counsel would utilize to evaluate compliance programs. And really the couple of things struck me about it. The first was how close it was to mimicking the 5 elements of an effective compliance program that you and Paul McNulty have developed and advocated over the years. The second thing was it started off with almost half of what you just said, which was the importance of the commitment of senior management, not only in financial support and resource support, but actually rolling up their sleeves and taking part in their role in compliance. So I was wondering if we might be able to get some of your thoughts on the metrics that Assistant Attorney General Caldwell laid out and how you think a company can go about showing that they complied with those.
Yeah, Tom, I think that's a great point because, the metrics help sort of define for the compliance officer what he or she needs to do. It also makes it easier to explain to senior management and the board what the expectations are. And as you know, and just suggested there, we talk from Baker & McKinsey about the 5 essential elements of compliance because we've really tried to simplify it because whether you take the U.S. sentencing guidelines, the OECD guidelines, the UK Bribery Act, industry-specific regulations, other government enforcement protocols, they really come down to 5 key elements of your compliance program. And if you meet those 5 elements, then you have a defendable program. And those 5 elements are leadership, risk assessment, standards and controls, training communications, and then remediation, which is your auditing, monitoring, and response. And it was really interesting because I was struck as well when Leslie Caldwell was talking about these. She was talking about key issues, and they all fit kind of into this 5 elements framework. What she was interested in, kind of were a couple key points that I think the department in the last few years has really been emphasizing. The things that they are most interested in during an investigation or disclosure process are the leadership, meaning, what is the tone at the top? What's the direction from, senior management and the directors? Really strong explicit support, which she talked about. And then do you have the right stature for the compliance person, meaning the right level, the right resources, and the right seat at the table with direct access to the board of directors? Then they're really asking about, is your program a risk-based program? Because that's what everything should be based off of. How do you have the appropriate policies and procedures and then training in place? And that's pretty standard, although you'd be surprised how many companies still struggle with that. And then it's really around, third parties and what you're doing, what has historically been around due diligence and understanding third parties, but now it's quickly moving into, are you actively working with your third parties to ensure that you have the right FCPA protections? Meaning, are you training them? Do you do certifications, contractual language? Are you doing auditing? How much more involved are you, especially with your high-risk third parties, which I think is going to be a huge driver for the trends of DOJ going forward. One of the things I thought was really interesting about Leslie Caldwell's comments is, she made a comment in there talking about the program and being able to demonstrate that you're continuing to enhance the program as you go forward. And, and I think that's one that companies do have a little problem with about, are you continually moving forward with your program? Are you assessing it from an ongoing risk standpoint? Are you making continual changes so you can show that enhancement? So those are really the key ones. that you think about. She pointed out as kind of the metrics that, it's the top-level leadership, it's the adequate resources, are the policies clear and in writing, understood by the employees, are they effectively communicated to everybody? How do you enforce the compliance policies? Are you enforcing them against lower-level people, but not necessarily high earners or high performers, especially, sales-related activities? And then how are you working with your third parties? So those are the metrics that they're looking at, and that's consistent with what we've seen over the last year or two in terms of disclosures and investigations. So I think that's a very good guidepost for compliance officers in looking at their own programs.
Let me drill down into one of those, because I've heard you speak really for several years about one of those that I don't think gets enough attention if your program is really not mature, and that's third parties. I think certainly everyone understands the need to have a questionnaire and some due diligence, a business justification, and contractual terms. But the way I've heard you phrase it, you talk about once you sign the contract, that's when your work starts, because you have to manage that relationship going forward. And that this metric seems to talk about really your starting point is when you sign the contract. They're assuming everybody's done a due diligence. How do you advise clients on the types of things to do going forward after they've signed the contract?
Yeah, to go to your point, what Leslie Caldwell talked about is that you need to be really sensitive around your third parties, so your vendors, agents, consultants, and that you're serious about compliance with those third parties. And that it needs much more than just boilerplate language in a contract or just base due diligence. That's at the base minimum standards. They expect you're going to see that everywhere. If you don't have it, then that's clearly a problem. But it also means being much more proactive with your third parties and taking action, if a third party is violating the law or there's a problem, terminating those relationships. For me, I've now started really talking to and encouraging clients to become more active on their third parties. It used to be kind of the view that the more active a company is with their third parties, the more liable you might be responsible for their actions. But from an FCPA standpoint, if they're representing your company, especially with government officials and working in high-risk jurisdictions or high-risk areas, you're going to be responsible for them anyway. So you might as well do things like enhanced due diligence, auditing on some kind of annual or ongoing basis, across your third parties, making sure that you have updated contractual provisions, annual certifications, and really trying to have them understand the culture and requirements for your business. And so it's a much more hands-on approach about looking at it. And this is especially true in the M&A, due diligence, post-deal integration area as well, for people that you're bringing into your company that you may not well have had a history with or understand the types of businesses that you're doing and working with those third parties. So, you're right, which is it's just the start to have, the initial contract done. There's a lot more work around third parties. And this is going to be a tremendous kind of area of focus continually for the DOJ. I mean, as you know, about 80% of the FCPA cases involve some kind of third party or agent working on behalf of businesses. And so, it's already a significant risk. Now the expectation is you're much more active in the compliance program and frameworks of your third parties and making sure they understand what your expectations are and checking it, because you can't just trust them to be doing it.
One of the other things that struck me about Caldwell's metrics and her remarks were the continuation of the theme that your compliance program must be evolving. It must be growing. Circumstances change, laws change, your business changes, everything is dynamic, including your compliance program. It's one of the 5 essential elements. You laid out some of the tools that a company can use, and I thought that's it's always good to revisit that, but you particularly speak about the difference between auditing and monitoring and how that can lead to helping your program evolve. Could you give us a few remarks about that in the context of what you see from Leslie Caldwell?
Yeah, so Leslie Caldwell talked about how that's important, although it's been, I think, relatively undefined even from the DOJ as well. The 2 areas where I see companies struggle the most are with risk assessment, meaning doing them and being effective about it, and we can talk about that down the road. The second one is really around this ongoing auditing and monitoring of compliance programs and what you can do internally through internal audit or your compliance office, what you use external providers to assist with, and there's kind of differences between auditing and monitoring. Auditing is really a snapshot in time look at certain issues. So you might look at transactions involving government officials, or licenses being required for a certain entity, or auditing travel and expense or entertainment as an example. Monitoring is really now more the proactive side of how do you see, on a daily basis, the things that are happening in your company. So are you coordinating information around your hotline, around your risk assessment, around, the various other organizations that are looking at this inside your company, like your ERM process or your internal controls or internal audit processes? What are you doing from kind of third-party risk? What are the other violations, of policy that you might have seen? And how can you coordinate all of that information to be able to see trends and hopefully move into a predictive fashion? There's a company or two that are starting to do this in a much more software aggregated type of way, but I think it's been very difficult for companies. Most of it is disaggregated information that people aren't using to really understand where the true risks are in their business. And that's why you go back to kind of the risk assessments. And one of the things I encourage companies to do, and especially compliance professionals, is, well, you and I spend a lot of time talking and dealing with FCPA issues for clients. It's a much broader compliance risk framework that compliance professionals need to worry about. I mean, you've got data protection and privacy and cybersecurity, and you have antitrust, you have, very significant trade compliance, import, export sanctions, customs-related issues, and then anything that might be relevant to your industry. You've got to be looking at all of those risks as you're doing the risk assessment. And, don't lose track just because FCPA is a very significant, potential problem for your business, that you also have other ones. I mean, trade compliance is a perfect example, or antitrust, where the fines there are actually even higher than the ones that are associated with FCPA. And so, thinking about your risk profile, how do you monitor those risks? How do you use the information that has come from previous places in your compliance program to be able to get more of a holistic picture of what's happening in your business? The other tools that you use, other than auditing, are kind of surveys, doing some testing, doing ongoing reviews, and then working again with, third parties to make sure that they are getting the same kind of training, communications, and information as your employees are.
You said something there that I don't think a lot of compliance practitioners focus on, but I really try to emphasize, which is the continuum of information that you have. And it really starts with a risk assessment, but it's only a starting point. And that risk assessment needs to be updated, but that updating forms part of your roadmap going forward, so that it's almost a continuous loop of input into a risk assessment back to the start through monitoring and auditing, which allows you to then fully assess or assess again where you may be for your next roadmap. I've also heard you talk about having a 1, 3, and 5-year plan. How would that sort of work into the evolution of a compliance program?
Well, it really depends on where you are in the stage of your compliance program. I try to talk about it in, base elements that would be expected, then, expected practices by the government, regulators, and then more advanced types of compliance initiatives. So for any given compliance officer, it really depends on where they are in that continuum from a compliance standpoint. I think most companies are really dealing with base elements and then some of the kind of things around specific topics like FCPA, and have a very good handle on that. Again, the areas where I find a lot of the weakness are really understanding the complexity of the risks that are involved, and across multiple channels of compliance topics, and then how do you really effectively audit or monitor for those, and then using tools that are out there to be able to have a lot more data and software capabilities that you're looking at being able to use to kind of show this Morgan Stanley defense. So showing that you meet these 5 elements, showing that you have data in real time to be able to evaluate the risk, that you move to some kind of predictive nature of compliance. I mean, as you know, I've been working with a company called Conversant very closely to build out this kind of software tool, because you just don't see it in the industry, and it's going to be where everything moves. And really being able to have a compliance management solution that can track all of these various inputs and show those data together by individual, by business location, by business unit, and be able to see whether you have problems with that manager, with that department, with that country, in a risk mapping activity, as opposed to what we're used to, which is either having to go in and do it in country on any given year, or trying to figure out from headquarters what might be happening with no inside visibility. That's where things are moving, and that's where, the programs become much more complex in terms of the information that they can see, report, and act against as people go forward.
Well, Stephen, unfortunately, we're to the end of our time. Just this week, there was a report in the Washington Post that the Department of Justice may be changing enforcement focus a little bit. So I may want to call you back in a week or two if that report turns out to be correct, and visit again on maybe your thoughts on that. But I will leave that one for another day. But if anyone wanted to follow up with you directly about any of the things you said or Caldwell's talk, the new Compliance Counsel, could they email you? And if so, how would they do it?
No, absolutely. I'd be happy to. And it's Stephen.martin@bakermckinsey.com. And so it's STEPHEN.martin@bakermckinsey, McKenzie.com, or they can find it on Baker and McKinsey's website, or contact you because you know how to reach me, of course. But it's been great to have this conversation with you. And you run the best blog out there, and it's always fun to see what you're talking about. And it's always entertaining to also read the stories. So I appreciate everything that you've been doing for the community, and be happy to talk to you about other issues.
All right. Well, thanks a lot, and look forward to continuing the conversation.
All right. Sounds good. Thanks.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. If you would like additional information on the new Compliance Counsel metrics, please check out my blog. I did a 5-part blog series on these new metrics. It can be found at the FCPA Compliance and Ethics blog, and you can find that at fcpacompliancereport.com. I hope you've enjoyed this, and I hope you will come back for additional episodes. Thank you very much for listening.